Thanks for your interest in this video, which will provide an introduction to technology law. This presentation will cover the interplay between law and technology and how these two domains have influenced and continue to influence each other. But first, what exactly is technology law? Is it a shorthand for the branch of law that is referred to as telecommunications, media and technology law, commonly referred to as TMT law? Or is it a specific reference to just the technology components of TMT law? For the purposes of this presentation, I will be using the phrase technology law to refer to the entirety of TMT law. Before moving on, it is worth noting that technology law is distinct from legal technology or law tech. Legal technology is about technologies that support, complement, or replace the traditional methods of production and delivery of legal services. The use of AI to assist with document review and using chatbots to provide legal answers are examples of such digitalization. This is law tech, which I will not be talking about. Technology law can be broken down into two big branches. Firstly, you have the laws that regulate technology, and secondly, there are established areas of law that are being shaped by technology. We will look at each of these in turn. First, we will explore the laws that regulate technology. I should state at the outset that the label laws that regulate technology is misleading. The law does not regulate technology in and of itself. Instead, it is more accurate to say that the law regulates how technology is applied and supplied. For example, the law does not regulate storage devices or media, but when you deploy storage equipment to provide hosting services, then the law regulates your data processing services. Technology may be categorized into multiple layers. For this presentation, I will be categorizing and examining the technology and the relevant laws under three broad categories. These categories are infrastructure, intermediaries, and content regulation. Telecommunication regulation pertains to the regulation of the provision of the communications infrastructure. This is sometimes referred to as the carriage layer. It comprises the following components: regulating how telecom services are provided and how telecom equipment are supplied. Second, the allocation of limited resources such as spectrum rights, telephone numbers, satellite orbital slots, and submarine cable landing sites. Third, imposing obligations to interconnect and the standards for interoperability of equipment and the interconnection of networks. Fourth, establishing standards for market behavior and consumer protection through the Telecom Competition Guide. And lastly, imposing standards to ensure the resilience and cybersecurity of telecom infrastructure. Next, we move on to the regulation of intermediaries. Internet intermediaries are usually online platforms whose role is primarily to link end users with other end users or service providers. This function is referred to as intermediation. Examples of intermediaries include search engines, e-commerce marketplaces, social media platforms, and app stores. Now, intermediaries enjoy protections from liability. These are usually in the form of immunities, such as those set out in Section 26 of the Electronics Transactions Act, or they can be in the form of safe harbor provisions, such as those set out in Division 2 of the Copyright Act 2021 for network service providers. To enjoy these protections, intermediaries are typically required to provide their services in a neutral and passive manner. They must also deliver these services through automated technical means. But there is increasing recognition that intermediaries can exercise some control over contents on their platforms. Consequently, there is an increasing expectation for internet intermediaries to act. In Singapore, this recalibration is exemplified in the enactment of the Protection from Harassment Act in 2014 and the Protection from Online Falsehoods and Manipulation Act in 2019. These acts require internet intermediaries to disable access or to communicate corrections when directed to do so. Further, there are now situations where internet intermediaries cannot be passive and neutral. The POFMA office has issued codes of practices that require prescribed internet intermediaries to give prominence to credible online sources of information. As you can see, these regulations leverage the intermediaries' gatekeeper role to give effect to public policy. Finally, we touch on contents regulation. Content is the broadest category. It can range from the provision of information to the provision of online services. Examples of online services are transactional services, such as online retail, or software as a service, such as online games. When it is about regulating the provision of information, and these can include videos, the area of law is more commonly known as media law or contents regulation. The Broadcasting Act is an example. It regulates the publication of online contents by internet content providers. Both publishers of curated content and authors of individual articles, such as blog authors, they are considered internet content providers. They have to abide by the conditions of class license and the Internet Code of Practice. Further, internet content providers can also include social media platforms that host user-generated content. They must exercise best efforts to ensure that user-generated content conforms with the Internet Code of Practice. Regulation of online services is largely subject to vertical or sectoral regulation. These include the Films Act, which regulates the provision of online gaming, and the Payment Services Act, which regulates electronic payment services. There are some horizontal regulations that apply more broadly and across different sectors. Examples include the Electronic Transactions Act, which regulates identity and trust services like digital signatures and certification authorities, and the Personal Data Protection Act, which regulates the collection, use, and disclosure of personal data. Having provided a map of how laws regulate technology, we turn to discuss why they are necessary. What are the policy objectives that such regulations aim to achieve? Well, first, technology laws help to enable adoption of technology by addressing legal ambiguities. A good example is the Electronic Transactions Act. Introduced in 1990, the ETA sought to position Singapore as a secure and trusted node where e-commerce transactions from around the world can be processed. To achieve this, the ETA granted legal recognition to electronic signatures, records, and documents. It also established how electronic records and electronic signatures can fulfill the requirements of writing and signatures. The Evidence Act is another example. Over the years, it has been amended a couple of times, first to introduce a procedure to certify that computer output is reliable, more recently by replacing this procedure with evidential presumptions. These amendments provide clear assurances that computer output is admissible as evidence. Next, technology regulations seek to define roles and clarify their responsibilities. There are various stakeholders in the public key infrastructure system for digital signatures. Their roles and responsibilities are set out in the ETA and its subsidiary legislation, the Electronic Transactions Certification Authorities Regulations 2010. These include the roles of the Controller and Certification Authorities, or CA, roles that are important to establish trust in the PKI certificates and the PKI system. The regulations define technical standards and clarify the responsibilities for each of these roles. Complying with the requirements in these regulations enables digital signatures issued by accredited CAs to qualify as secure electronic signatures, and these enjoy additional evidential presumptions. Fulfilling the regulatory requirements also limits the liability of an accredited CA. These are examples of how regulation can promote adoption of standards. Thirdly, Thirdly, some laws provide the authorities with new enforcement powers to help establish online safe spaces. One example is POFMA, which seeks to curtail the electronic dissemination of falsehoods on both open platforms such as Twitter and Facebook and closed platforms such as private instant messaging groups. It achieves these goals through a variety of new regulatory tools that are crafted for the digital environment. For example, correction directions that require a person who has communicated a falsehood to publish a notice that points to the correct facts or information. Another example is a disabling direction, which requires the internet intermediary to disable access by end users in Singapore to the false statements of fact. Finally, some laws, such as the Computer Misuse Act, seek to protect computers and data. The Computer Misuse Act criminalizes various acts that could impact or impede the functioning of computer systems. These include the unauthorized modification of computer material or the unauthorized interception of computer services. Section 10 of the Computer Misuse Act sets out enhanced punishments for offenses that involve a protected computer. An example of such a computer is one that is used directly in connection with Singapore's defense or international relations. Another example is the Personal Data Protection Act, which imposes obligations on organizations that process personal data. In gist, organizations have to protect personal data in their possession or under their control from unauthorized use, modification, or disclosure by employees as well as external parties. Additionally, they are required to provide individuals access to their personal data and to correct any errors that they may find. We now move to the established areas of law that have been shaped by technology. Infocom and media technologies touch every aspect of our business and private lives. It is therefore not surprising that it will leave its mark in most, if not all, areas of law. The bulk of these seminars in this series will cover different areas of law and how Infocom and media technologies have shaped them. In this slide gives an inkling of the breadth of its reach. I will use artificial intelligence and blockchain to illustrate. Let us start with AI. I organize my thoughts in two segments. First, AI and intellectual property law. Machine learning systems are the form of AI that have the most prominence these days. The training of machine learning models requires access to large datasets. Machine learning models identify relationships and build patterns from the underlying data, and they extrapolate these to make recommendations or predictions. New exceptions to copyright have been introduced to facilitate access to and use of data for machine learning model training. In the EU, this takes the form of Articles 3 and 4 of the EU Directive on Copyrights in the Single Digital Market. These articles allow for reproduction and extractions from databases for the purposes of scientific research, text, and data mining. Singapore has moved on this as well. We recently enacted Sections 243 and 244 of the Copyright Act 2021 to include a computational data analysis exception. The increasing use of machine learning systems to generate works is also starting to push the boundary in intellectual property law. Take GPT-3 as an example. It is a deep learning language model that can generate human-like text. It is so human-like that a study showed that humans could detect GPT-3 generated articles only 52% of the time. If I make use of GPT-3 in a system that generates case summaries of lengthy grounds of decision, should the output enjoy copyright protection? Some jurisdictions already provide for this. Section 9(3) of the UK's Copyright Designs and Patents Act 1988, for example. It allows computer-generated works to enjoy copyright protection, and the person who undertook the necessary arrangements for the creation of the work is the author. Singapore has introduced similar provision in Section 4(5) of the Registered Designs Act, but not the Copyright Act. Next, we look at blockchain and how common law has had to deal with its manifestation in the form of cryptocurrency. The case of Coin and B2C2 concerned algorithmic trading in cryptocurrencies. Algorithmic trades were concluded without human intervention. A dispute arose over the reversal of 13 trades that were concluded between B2C2 with other users, and these trades were 250 times the prevailing market rate. There were allegations about coding issues. This case developed the doctrine of unilateral mistake, carrying on the tradition of the earlier e-commerce case Digiland Mall, which has become a locus classicus on this topic. This case clarified how to determine the issue of knowledge, which is central to the doctrine of mistake in the context of algorithmic trading that is reliant on deterministic as opposed to probabilistic algorithms. In gist, it is the programmer's state of knowledge, beginning with the time of programming until the trades in question that is relevant, and knowledge here covers both actual and constructive knowledge. Next, can cryptocurrency be a species of property? The Court of Appeal in Coin thought that it could be, but left the question open. This has now been answered in the recent case of CRM and CRN. Cryptocurrency can be property because it satisfies the 4 requirements in Ainsworth. First, cryptocurrencies were definable and sufficiently distinct that it can be allocated to account holders. Second, they were identifiable by third parties in that the rightful account holder can exclude others by virtue of the use of this private key. Third, cryptocurrencies were capable of assumption by third parties since there is an active market trading in cryptocurrencies. And fourth, they have some degree of permanence or stability since they exist under the control of the account holder until he chooses to spend or transfer it. These are just 2 examples to illustrate how AI and blockchain technologies have touched and shaped copyright, contract, and property law. Thank you for listening to this lecture. I hope it has enriched your understanding of the interplay between law and technology. I trust that you will find the rest of the lectures in this series informative and eye-opening. Thank you once again and have a good day.